Welcome, everybody. Welcome to today's episode of The Law of Self-Defense. I actually forgot. I forgot to do all the settings on YouTube. Hopefully it streams okay. Let's see if I can do those while we're live. Take care of all that social media nonsense. Maybe Shane got in here and took care of all that. That would be awesome. Let me go back here, make sure I didn't break everything. All right. Well, we are streaming on the YouTube and on the Law of Self-Defense member stream, members only. And let's see. How about on X? Yes, we are there as well. And then poor old Rumble. Sometimes it works. Sometimes it doesn't. Well, folks, I am, of course, attorney Andrew Branca for the Law of Self-Defense. A relatively rare Saturday show, but I've been traveling for the last week. Just got back from Nashville, Tennessee. The wife and I, Emily and I, are looking for a new home, new schools for the kids, fleeing from Colorado. Our current home state of Colorado, quickly becoming California, going crazier and crazier. So we're looking for a better environment in which to raise our two girls. And we spent the last week in Nashville. Took a trip up to Louisville, Kentucky, too, as part of the week. Well, I have to say, I really like Nashville. So we have more places to look, but Nashville remains high on the list. So, folks, if you're having any trouble streaming or anything like that, it's nothing I can do about that. Sorry. It looks okay on all the streams from where I'm sitting. So back from Nashville, I had hoped to be able to do some shows while I was traveling, but it's a lot easier to find a niche of time to live stream a show when I'm traveling by myself on the motorcycle than it is when I'm traveling with a wife and two kids in a hotel room that didn't even come with a desk. That's what happens when I let Emily book the hotel room. She looks for characteristics other than my work convenience when we're traveling as a family. So I didn't get to do any live streams this past week. Putting this one in for all you Law of Self-Defense members, I have to apologize again. I do have several days of family obligations next week. The in-laws are celebrating their 50th wedding anniversary. It's going to be a multi-day event. It's local here in Colorado, so I don't have to travel anywhere, but it's going to be a bit time consumptive. So I'll do what I can. And then shortly after that, Will Parker, who I see here in the chat, Will Parker, firearm self-defense instructor up in Montana, graduate of the Law of Self-Defense instructor program. Great guy, great shooter, great instructor, very well informed on self-defense law. He and I will be taking a motorcycle trip around Colorado, so that'll be fun. I just received in the mail my new GoPro camera, so I'm going to try to film this one. This new version is supposed to be able to capture the audio from our intercoms. First time ever being able to do that wirelessly, I'm told. So I'm excited to give it a shot. All right, so today we are here to talk about this. The motion to dismiss Alec Baldwin's indictment is denied. So a few weeks ago, the defense team for Alec Baldwin, mostly Manhattan civil litigation attorneys, but a big team of people from Quinn Emanuel, one of the top 50, maybe higher, law firms in the world. So a huge law firm filed a motion, as they filed tons of motions in this Alec Baldwin manslaughter trial case. Part of what they're doing, it's obvious their strategy is to kind of overwhelm the prosecution with all these motions. And you have to respond to the motions filed by the defense or you waive the legal issues. So if you want to remain in the fight, you have to be responding to the motions. It can be very time consumptive. It's kind of the reverse of what was done to Derek Chauvin in his trial, where the state had like 15 prosecutors on the case. There was one defense lawyer, and they were filing motions every night of that trial. And that defense lawyer had to be in court arguing for his client all day, every day. And then at night, he had to respond to all these motions. It was clearly a travesty of justice. But that's what the defense is doing partly here. It's why the special prosecutor, Kari Morrissey, has brought on a new colleague, an experienced prosecutor. Kari Morrissey herself is a career defense attorney. I believe this is her first role as a prosecutor. So she's brought on an experienced prosecutor to help her manage the case, which is all to the good. But a few weeks ago, the defense had filed a motion to dismiss the grand jury indictment against their client, Alec Baldwin, of course, charged with manslaughter in the shooting death of Halyna Hutchins, cinematographer, on the set of the low-budget Western movie Rust. We saw, well, it's June now, so I guess it's 2 months ago, that Hannah Gutierrez, the armorer on that movie set, was found guilty of manslaughter, sentenced to 18 months in prison, and tagged as a violent offender, so she's got to do 85% of that 18 months, as opposed to the normal 50% under New Mexico law. 18 months, by the way, is the maximum for manslaughter under New Mexico law. And now it's coming up on Alec Baldwin's turn. He's scheduled to go to trial with jury selection on July 9th and the trial starting July 10th. I will, of course, be live streaming the trial, maybe with Joe Neerman. I'm talking with Joe, Good Logic, about kind of co-live streaming so that we can, it's more fun when you do it with somebody else and we can give each other breaks and stuff like that. We'll see what happens. But I certainly will be live streaming the trial one way or another. So the defense team for Alec Baldwin had a bunch of arguments about why the grand jury indictment against their client was defective, they claim, and therefore it ought to have been dismissed. And I've read their motions on previous law self-defense shows. And then the Friday before last Friday, so a Friday ago yesterday, the court with in the form of Judge Sommers here in the thumbnail had oral argument, virtual oral argument via Zoom or similar platform. I forget what they used. Had oral argument on these motions to dismiss, and of course the counter arguments by the state not to dismiss the grand jury indictment. And I have to say, I thought when I read the motions by the defense, I thought they really didn't have legal substance, that it was a lot of theater in there, a lot of angry rhetoric, but very little legal substance. I thought the responses by the state, by Kari Morrissey, were kind of weak too, frankly. She could have done a much stronger job, I think, on the legal merits, which made her vulnerable legally on this grand jury indictment question. And then when they had the oral arguments, Judge Sommer was really tough on Prosecutor Kari Morrissey, asked a lot of hard questions. And if I had based my projection on the outcome, which I really don't do, on the demeanor of Judge Sommer in that oral argument, I would have said that she's likely to grant the dismissal of the indictment. In fact, she did not do that. She denied the motion to dismiss the grand jury indictment, largely along the lines of what I had argued to all of you were the weaknesses in the defense case for dismissing the indictment. A lot of what the defense had to argue about was that previous prosecutors no longer involved with the case had done bad things, that a third-party hearsay, an anonymous source anonymously cited in a media report said that Kari Morrissey said mean things, that the defense would claim that the prosecution had a legal obligation to not just make the grand jury aware of arguably exculpatory evidence, but to actually present that exculpatory evidence to the grand jury. I said that wasn't the case. There's a difference between making evidence available and actually presenting it in a form of argument to a grand jury, and a bunch of other things. I'm not going to go through them all here. Time is a little tight, and I will cover them as we go through the Judge Sommer's order denying the motion to dismiss the grand jury indictment. What this almost certainly means is we're going to trial. So I don't see any way that Alec Baldwin will avoid now going to trial. And I believe if he goes to trial and it's in front of anything like an objective, unbiased jury, an involuntary manslaughter conviction is a lock. I don't see how this does not qualify as involuntary manslaughter, as I've been arguing since the day after the shooting occurred, when I wrote my first blog post on this tragic but avoidable event. Let's see. Yes, Ian Runkle, Canadian lawyer out of the Edmonton area. He was in Nashville last week too. I didn't get a chance to connect with him, but apparently, unbeknownst to me, I didn't discover this until after I was in town to do the house and school hunting. There's a conference taking place in Nashville, the Crime Conference. Ian was attending that in Nashville, and as well as some others of the LawTube type community. I've never heard of this event, or I would have tried to have gone myself, get a speaking invitation. Maybe I'll do that next year. But I hope and trust that Ian had a great time at the event. And I get to see Ian once or twice a year, usually anyway. So look forward to the next meeting. Sorry I wasn't able to connect with him this time. Let's see. So with that said, let's go ahead and jump into the formal launch of today's show. And that showed me that I did not have the correct audio settings. So hopefully the microphone hasn't been too bad. Also, I have to pull up my little slide with the our sponsor, which today is, oh, come on. There we go. CCW Safe, a provider of legal service memberships, what many people mistakenly call self-defense insurance. In effect, CCW Safe promises to pay their members' legal expenses if the member is involved in a use of force event, is compelled to use force in defense of themselves, their family, their property, and finds themselves facing legal liability afterwards, either criminal or civil. CCW Safe does a lot more than just pay legal expenses for its members. It flies in its own very experienced investigative team. So you have investigators working for you. Otherwise, the only investigators are working for the prosecution, folks. I think the world of CCW Safe. I do a lot of partnering with them. There are other companies that offer or purport to offer similar services out there in the marketplace. Some of them are certainly worth considering. I think they're all slightly different flavors. So what's the best fit for you might vary depending on your circumstances. Some of the offerings out there are dumpster fires that I could not possibly recommend to anybody in good faith. CCW Safe is one of the ones I trust. Indeed, I trust it so much that I'm personally a member of CCW Safe. My wife, Emily, is personally a member. If you'd like to learn why I trust them, I have a little video explaining it at lawofselfdefense.com/trust. And there at that URL, you can also find a 10% discount code for when you become a CCW Safe member, after you determine that it's the best fit for you, as it's the best fit for me. lawofselfdefense.com/trust. All right, let's get to this order. Make this a little bigger. Issued 5/24, and I believe, let's see, the oral argument, yeah, so it was a week after the oral argument. The oral argument was Friday, May 17th. I did a show on it the following day, doing a stream of the live stream of the oral argument on Saturday, May 18th. And a week after the oral argument is when Judge Sommer issued this order. So a week ago yesterday, on May 24th. And let's go ahead and get this party started. This matter came before the court on. So this is a decision by the judge. So motions are requests for the court to do something. An order is the court making a decision about what it's going to do and explaining its decision, its rationale for arriving at that particular decision. So order denying defendant Alec Baldwin's motion, which you should understand as request to dismiss the grand jury manslaughter indictment against him. This matter came before the court on defendant Alec Baldwin's motion to dismiss the indictment, filed March 14th, having reviewed the briefing, considered oral argument, and being otherwise fully advised. The court, that's Judge Sommer, finds, concludes, and orders the following. First, there's a procedural summary. On March 14th, 2024, defendant Alexander Ray Baldwin III, the defendant or target of the grand jury, filed his defendant Alec Baldwin's motion to dismiss the indictment. Thereafter, on April 5th, 2024, the state filed its response. In turn, on April 22nd, the defendant filed his reply in further support of the motion to dismiss. The parties engaged in additional briefing concerning a requested surreply by the state. However, the court denied the state's request and decided to go right to oral argument. On May 17th, 2024, the court entertained oral argument on defendant's motion to dismiss Special Prosecutor Kari Morrissey appeared and argued on behalf of the state. Defense counsels Alex Spiro and Luke Nikas, these are both partners in that top 50 Manhattan law firm, Quinn Emanuel, appeared and argued on behalf of defendant. Following argument, the court reserved ruling on defendant's motion to dismiss. So after oral argument, the court said, next week, I'll give you my order. And she did it exactly a week later. Factual background. Defendant's motion to dismiss primarily concerns the state's presentation of an investigation into then target Baldwin to a Santa Fe County grand jury on January 18th, 2024 and January 19th, 2024. In advance of this grand jury presentation, the state filed two motions. One motion concerned whether the state had to present target offered evidence to the grand jury. The second motion concerned whether the state had to provide target requested jury instructions to the grand jury. So to put this in context, the defense has been offering up a ton of evidence it calls exculpatory that I would argue is not really exculpatory. It's testimony, would-be testimony by people like David Halls, the first assistant director, a variety of other people on the set of the movie who would all say nice things about Alec Baldwin and say how they believe he didn't do anything wrong and shouldn't be held legally accountable. None of those sentiments are relevant to the actual elements of the criminal charge against Alec Baldwin. So although they are nice things said about Alec Baldwin, they're not exculpatory in a substantive sense, in the sense that they would mitigate or relieve Baldwin of legal liability on the facts and law of the case. So the first thing I would argue is all this evidence the state wanted presented was not relevant. And if it's not relevant, it's not exculpatory in any substantive sense, and there is no obligation to present it. In any case, even if there was exculpatory evidence, genuinely exculpatory evidence, I've argued continuously that the state may be obligated to make that evidence available to the grand jury, to make the grand jury aware that there is evidence the defense is claiming to be exculpatory. Would you like to see it? What the state's not required, in my opinion, to do is to actually make a presentation of that evidence. And what the state did here was make it available. They said, hey, so what happens is that the defense gets to have presented to the grand jury, actually presented, what's called a target letter or an alert letter. The target of the grand jury, not yet a defendant because he's not yet indicted, but the target of the grand jury here, of course, is Alec Baldwin. And the defense has the opportunity under New Mexico law to alert the grand jury to evidence they believe is exculpatory. And they get to write this in the form of a letter called an alert letter, and that letter is shared with the grand jury. In this case, the prosecutor actually literally read the alert letter to the grand jury, word for word, and then gave each of the grand jurors, 22 or 23 of them, a printed copy of the alert letter. And so the alert letter is basically a narrative of the defense version of why their client shouldn't be indicted, and bullet points of the evidence they would like the grand jury to consider in arriving at a no true bill, at a not indictment. So the grand jury was made aware of all this. They were told The defense witnesses, if the grand jury wanted to hear from them, would be made available. The grand jury has subpoena power, so they can compel witnesses to appear. They had boxes of documents that the defense had prepared that were sitting there in the grand jury room, and the state said, there's boxes of evidence being offered by the defense. If you'd like to consider it, you can. In fact, the grand jury declined to hear from any of the defense witnesses or look at any of the defense evidence. And the defense is arguing, well, that wasn't enough to make them aware. You also had to actually present it. You had to put together a PowerPoint. You had to bring in the witnesses. You had to present the evidence in the boxes to the grand jury. And the state didn't do that, the defense says. Indeed, the state did not do that. But the defense says the state was obligated to do that, and its failure to do that means the grand jury indictment is defective and should be dismissed. All right, continuing now. On November 15th, 2023, the state filed a state's expedited motion to preclude targets' requested testimony and evidence before the grand jury. So the state was trying to keep out defense testimony, evidence, probably because it's the kind of stuff I'm talking about. Kind statements by other people, like David Hall, but not relevant to any element of the criminal charge or any legal defense. Let's see. The November 15th expedited motion concerned the state's objection to then target's proposed evidence alert letter provided to the prosecution. Ultimately, the Honorable T. Glenn Ellington, who was the judge at that time who was in charge of this prosecution, now the case has been handed over to a different judge, Judge Morrow, who's writing this order. But she's going to respect Judge Ellington's rulings, prior rulings. That's normal. Ultimately, the Honorable T. Glenn Ellington, in his role as grand jury judge, instructed the state to alert the grand jury to nearly all of the evidence set forth in the target's evidence alert letter. And Judge Ellington did this in his own order. So an order is binding on the parties. Told the state, ordered the state, you have to alert the grand jury to all this defense evidence, virtually all of it. Then on December 1st, 2023, the state filed its state motion to exclude targets requested elements instructions to the grand jury. So the first objection of the state was to the evidence, and they lost that argument. The judge in charge, presiding over the grand jury, said, no, you have to alert the grand jury to the defense evidence. The defense had also offered a jury instruction that the state objected to for good reason. As we've discussed before, it did not pattern after the New Mexico standard jury instruction. It changed the law effectively, and the state objected to that. So there was a motion to exclude concerning the state's objection to jury instructions proposed by the then target for consideration by the grand jury. Thereafter, Judge Ellington entered an order granting in part and denying in part the state's motion to include the instruction, the jury instruction. The order concluded that certain jury instructions proposed by the defense materially differed from the standard New Mexico jury instructions for manslaughter, which are listed here. 14-231 is the New Mexico manslaughter jury instruction that's relevant here. Therefore, the court granted the state's requested exclusion of the defense offered criminal negligence standard instruction. So the judge in charge at that time said, nope, the defense jury instruction is different than what New Mexico law requires, so I'm not going to order the state to provide that jury instruction to the grand jury. On January 18th and 19th, 2024, the state presented an investigation concerning then target Baldwin to a Santa Fe County grand jury. The state called the following witnesses to give testimony during the grand jury presentation. Corporal Alexander Hooters Hancock. She was the lead investigator on the case. Marissa Popple was a crime scene investigator. Michael Haig was a civilian firearms expert witness for the state. On the mechanics of how guns fire. Brian Carpenter was another expert witness for the state on the role of an armorer on a movie set. Ross Adiego, he was the camera operator working beside cinematographer Halyna Hutchins when she was shot and killed. Excuse me. Lane Looper. I believe Lane Looper was one of the cameramen who quit the day before or the morning of the shooting. And Connor Rice, I only have a vague collection of who Connor Rice is. He might have been one. I just don't remember. I would be guessing. Maybe they'll tell us in this order. In addition, at the beginning of its presentation, the state read the then target's evidence alert letter verbatim to the grand jury. So again, this alert letter was written by Alec Baldwin's defense team, and it sets out all the evidence they want the grand jury to consider. And the prosecution has to make that evidence available to the grand jury. And that letter, written by the defense, was read verbatim, word for word, to the grand jury. After the grand jury considered witness testimony, the state provided the grand jury with instructions, jury instructions, based upon the following uniform jury instructions or applicable statute, and modified to reflect the probable cause standard assessed by grand juries. That would be UGI 14231. That's the involuntary manslaughter essential elements. There's two, by the way, there's two theories here for getting to involuntary manslaughter. One is that Alec Baldwin was acting in an unlawful manner, and that's what resulted in the death of Halyna Hutchins. And the unlawful manner would be the negligent handling of a firearm. So there's a predicate crime. Negligent handling of a firearm is a misdemeanor offense under New Mexico law. It's a separate crime. So one theory to get to involuntary manslaughter is you're doing something unlawful here, negligent handling of a firearm, and that results in someone's death. The other way to get to involuntary manslaughter is in the same involuntary manslaughter statute, but it says you were acting lawfully, but without due care and circumspection. I mean, it works out to the same thing, but it's two different paths to get to involuntary manslaughter. That's why that same jury instruction is listed here twice in A and B. UGI, Uniform Jury Instruction 14-231. Then they had 14-133, the jury instruction that defines negligence and recklessness, mental states required for criminal liability. UGI 14251, what constitutes proximate cause for a homicide. UGI 14252, homicide, negligence of deceased or third party, if somebody else contributed to the cause of death. UGI 14-8006, grand jury proceedings, definition of what qualifies as probable cause. Because the grand jury is burdened with determining whether or not probable cause exists to believe that the target committed the alleged crime, and if they conclude that's true, then they issue an indictment, and that target becomes a defendant on their way to trial. Continuing now, following the state's presentation and instructions, on January 19th, the grand jury returned a grand jury indictment against defendant charging count 1, involuntary manslaughter, premised on negligent use of a firearm, and alternative count 1, involuntary manslaughter, acting without due caution or circumspection. The defendant now challenges the grand jury proceedings, analysis, and ruling. Defendant's motion to dismiss makes 6 primary arguments in support of the requested relief of dismissal. First, defendant argues that the state exhibited bad faith in seeking the indictment against defendant Baldwin. Second, if they can show bad faith, by the way, there are reasons that would justify just automatic dismissal of the indictment. Second, but the bad faith is largely premised on these third-order hearsay statements. So some anonymous person told an anonymous person who told the journalist who wrote in a media report that Kari Morrissey had said something, which the judge could consider, but let's admit it's not the most forceful of evidence. Second, the defendant asserts the state withheld exculpatory and favorable evidence from the grand jury. This is that issue of whether the state had to simply make the evidence available, the allegedly exculpatory evidence available, or whether they actually had to present it, make a presentation of the defense evidence. Third, the defendant contends that the state provided an inaccurate jury instruction to the grand jury. I've covered this at some length. Fourth, that just means the state presented a jury instruction that was unfavorable to the defense, is all that means. The defense wanted a jury-rigged jury instruction that did not reflect New Mexico law that was favorable to their client. Fourth, the defendant asserts the state failed to advise the grand jury of its authority to order the presentation of evidence and witnesses beyond those offered by the state. This is just sleight of hand argument here because the grand jury is informed about their duties and powers, not just by the prosecution, but also by the presiding judge, Judge Ellington. And Judge Ellington told the grand jury of its authority to order the presentation of evidence and subpoena witnesses. So the state didn't, but the state explained in the oral argument, well, we didn't because the judge had just told them that. Fifth, the defendant argues that the state failed to follow the instructions of the grand jury judge. And sixth, finally, defendant contends that the state's response constitutes a waiver of many arguments and objection raised in defendant's motion to dismiss. So this is more sleight of hand by the defense, although in fairness, Kari Morrissey opened herself up to this. So the defense made a lot of really silly legal arguments in some of its motions. And Kari Morrissey didn't address those silly arguments head on, citing case law and statutes. And the defense then tried to characterize her failure to do that as having waived on that legal argument. So they win automatically because she failed to address the argument, however silly, in a more substantive way. That's because she's just overworked, is what really happened there. So, summary of law on challenges to grand jury indictments. Challenges arising from grand jury proceedings ordinarily fall into two categories. One, challenges to the quality or sufficiency of the evidence before the grand jury. And two, structural challenges involving the manner in which the grand jury process has been conducted. So the first is, was there enough evidence of guilt that a rational grand jury could find probable cause and therefore correctly return an indictment? And the second is, well, was the process itself so inherently defective that you didn't get a fair outcome? With respect to the challenges to the sufficiency of the evidence before the grand jury, the relevant statute provides the sufficiency of the evidence upon which an indictment is returned shall not be subject to review by some other judge, absent a showing of bad faith on the part of the prosecuting attorney, which is why the defense is arguing bad faith here. With respect to the process challenge, if the prosecutor does not strictly adhere to the grand jury statutes and procedural rules designed to protect the target's rights and ensure the fundamental fairness of the proceeding, the structural integrity of the grand jury process is compromised, along with the grand jury's determination of probable cause. Further, if the target of a grand jury investigation establishes pretrial that the grand jury proceedings were conducted in violation of these structural protections, the target is entitled to dismissal of the indictment and is not required to demonstrate prejudice or bad faith. Appellate courts have found structural protection violations in the following instances. In Herrera v. Sanchez, the New Mexico Supreme Court found structural protection violations when the prosecutor unlawfully prohibited a target from providing testimony in response to a grand jury's question and when the grand jury received inadequate instructions on the law. Well, that didn't happen here. At least the first of these didn't happen. Alec Baldwin was free. The target is always free to testify before the grand jury if he wants. Of course, then he's subject to cross-examination. So Alec Baldwin chose not to testify to the grand jury here. But the state didn't prevent it, as it did in Herrera. So that error is not here. And then the second part of Herrera is the grand jury received inadequate instructions on the law. As we'll see, that's just not the case here. Second, in Leon v. Hartley, the New Mexico Supreme Court concluded that a structural protection violation occurred when the prosecutor excused grand jurors without involvement by the district court. Third, in State v. Ulibarri, the New Mexico Supreme Court determined that a prosecutor's failure to instruct the grand jury on the record of the essential elements of offenses constituted structural error. Fourth, in Baird v. State, the New Mexico Supreme Court found a structural protection violation when the prosecutor was amongst the grand jury during its secret deliberations. So the prosecutor apparently was sitting in the room. That didn't happen here. Fifth, in David v. Traub, the New Mexico Supreme Court concluded a structural error occurred when an unauthorized individual was present during the course of a grand jury presentation. That didn't happen here. Last, in State v. Pareo, the New Mexico Court of Appeals found a structural protection violation when the prosecution did not afford the defendants their right to testify to the grand jury. That didn't happen here. And inadequately instructed the grand jury regarding such right. That didn't happen here. The Judge Sommer continues, other than the two categories of challenges identified above, New Mexico appellate courts have limited other substantive reviews of proceedings before a grand jury. That's just stuff we're not going to do, the judge is saying. I'll skip over some of this in the interest of timeliness. When there is a dispute over evidence, the prosecutor has broad discretion as to what evidence to present, to exclude from the grand jury, and courts will not review any good faith decisions the prosecutor makes in that regard once an indictment is returned. There is no post-indictment relief for a defendant once the grand jury returns an indictment absent a showing of prosecutorial bad faith in the context of an argument of inadequate evidence to support probable cause. But Judge Sommer does away with the bad faith argument here in Section B. The court does not find prosecutorial bad faith. In State v. Digman, the New Mexico Court of Appeals explained the meaning of bad faith in the context of challenges to a grand jury indictment. The Court of Appeals held that bad faith meant dishonesty of belief, purpose, or motive. The Court of Appeals added that for bad faith to exist, the prosecutor must have engaged in intentional misconduct, not simply negligence or even recklessness. Further, in State v. Martinez, the New Mexico Supreme Court explained, we note that Section 31.6.11a appears to address bad faith in presentation of evidence to the grand jury, such as deceiving the grand jury as to the probative value of evidence, but not finding bad faith in the initial acquisition of probative evidence that may be subject to suppression at trial. Probative evidence is evidence. Probative means it would help the jury, here a grand jury, determine whether a claimed fact is more or less true. And there could be different probative weights, right? Some evidence is more compelling of truth than others. Like the triple hearsay the defense is offering to show bad faith on the part of Kari Morrissey. Not very probative evidence. Not much weight of probative evidence. Other than the guidance provided by the cases of Digman and Martinez, this court, the Judge Sommer court, could not find, and the parties do not offer, additional authority defining prosecutorial bad faith in the context of a grand jury presentation. Nonetheless, while the court recognizes that defendant cites numerous instances of alleged prosecutorial misconduct leading up to the grand jury proceedings, and instances of the prosecution purportedly presenting quote-unquote false testimony to the grand jury, this court does not find that defendant has established prosecutorial bad faith. In other words, after review of transcripts from the January 18th, 19th grand jury presentations, the court does not find that the prosecuting attorney assisting the grand jury engaged in intentional misconduct, reflecting dishonesty of belief, purpose, or motive in the course of the attorney's presentation of evidence to the grand jury. So bad faith is off the table in terms of the indictment as far as Judge Sommer is concerned. C, the court does not review the state's decisions regarding evidence presented to or excluded from the grand jury in the absence of bad faith, which the judge just found did not exist. Defendant argues the indictment must be dismissed because the state withheld exculpatory and favorable evidence from the grand jury. In support, defendant claims the state was required to elicit exculpatory testimony from David Halls, the first assistant director, and Joel Souza, the director of the film, also struck by the bullet fired by Alec Baldwin. The defense argues the prosecutor was also required to provide the grand jury with specific documents identified in Baldwin's alert letter that reflect these and similar exculpatory statements from both witnesses. The court disagrees with defendant for three reasons. First, the defendant conflates a prosecutor's duty to alert the grand jury to target offered evidence with the prosecutor's discretion to present exculpatory evidence. Bam! This is what I've been saying from the beginning, folks. There's a difference between making evidence available on the one hand, should the grand jury want to see it, so it's accessible to them, and actually doing a presentation of defense evidence by the state to the grand jury. Those are two different things. Making it available, hey, if you want to look at it, it's described in the defense alert letter, which I read to you and gave you copies of. If you want to hear from these witnesses, if you want to look at their documents that they've offered, it's right here, and we'll make those witnesses available. But it's up to you. That's different than Kari Morrissey has to actually present these documents or present these witnesses. And Judge Sommer is recognizing that distinction here. The New Mexico Supreme Court's holding in Jones v. Murdoch unravels these concepts. Citing now from that decision, the heart of this case involves the statutorily created right of the target to alert the grand jury to exculpatory evidence. The provision at issue does not purport to command the grand jury to accept the target's evidence. Instead, the provision simply identifies the prosecutor as the conduit by which a target may alert the grand jury to pertinent evidence. As such, the provision at issue in this case does not diminish the grand jury's prerogative to weigh the evidence before it as it sees fit in making an independent decision whether to indict. Indeed, the grand jury is not even required to hear the evidence once it is made aware of its existence. But the grand jury cannot choose to ignore what it does not know. So it has to be made aware of the availability of the evidence. That's the purpose of the alert letter. The 2003 amendments also eliminate the prosecutor's duty to present evidence that directly negates guilt. So that was quoting from the supporting decision. The Judge Sommers continues, therefore, this court concludes that the prosecution was not required to present, and the grand jury was not required to order, target offered exculpatory evidence. The second reason this argument fails for the defense, as decided in State v. Yaw, quote, the prosecutor has broad discretion as to what evidence to present to or exclude from the grand jury, and courts will not review any good faith decisions the prosecutor makes in that regard once an indictment is returned, close quote. Therefore, in the instant case, because the court has not found prosecutorial bad faith, the court will not will not engage in a post-indictment review of the evidence submitted to the grand jury. Third, while the court acknowledges defendant's argument that Morrissey diverted the grand jury from hearing exculpatory evidence by redirecting grand juror inquiries to her own witnesses, the court does not find that this conduct amounted to structural error, as akin to found in Herrera. Critically, in Herrera, the prosecutor prohibited the target, who has a statutory right to testify, from answering a direct question from a grand juror. In addition, the prosecutor's action in Herrera had the effect of chilling additional questioning by the grand jury of that target. Regarding this case, the Baldwin case, in at least 5 separate instances, a grand juror posed a question to a witness who the prosecutor considered not qualified to answer the question. This happened a number of times, and I'm speaking now. Attorney Andrew Branca is speaking. This happened a number of times where a grand juror would ask a question of a witness who Kari Morrissey thought was not as well informed on the issue as another witness that was coming up. And Kari Morrissey would say, well, I'm not sure this is the right witness. but we have another witness coming up who can answer that question for you, is better positioned, better performed. So Kari Morrissey repeatedly, 5 times, I guess, said things like, we have an expert who works on movie sets, and he's going to answer those questions for you. So I recall in that particular case, the grand jury had posed a question about how things are done on movie sets to Detective Alexandra Hancock, who's never worked on a movie set. So Kari Morrissey jumps in and says, well, she's never worked on a movie set, but we have an expert on working on movie sets. He's going to answer those questions for you, if that's okay. Another case, is it okay with you if we address that question to a different witness? You're going to get more testimony in this and photographs that I think is going to help. We've got other witnesses that I think are going to be able to address that better, and so forth and so on. Judge Sommer continues, however, because these questions were not posed directly to the target, who has a statutory right to testify before the grand jury, the court concludes that Herrera is not directly applicable to this case. Further, the deferral of questions did not have a chilling effect, whereby the grand jury thereafter refrained from posing additional subsequent questions. Thus, in this respect, the current case is also distinguishable from the factual scenario analyzed in Herrera. In addition, in State v. Digman, the New Mexico Court of Appeals explained, we understand Herrera to require an assessment of the prosecutor's actions viewed under the totality of the circumstances in order to determine whether they prevented the grand jury from making an independent inquiry into the evidence supporting a determination of probable cause. Judge Sommer's writes, viewed under the totality of the circumstances, the court does not find that the prosecutor's deferral of questions prevented the grand jury from making an independent inquiry into the evidence supporting a determination of probable cause. Although the state deferred certain questions, in many other instances, the grand jurors asked probative questions and received complete answers from witnesses without state interference. Therefore, the court concludes that the prosecution's deferral of the grand jurors' questions does not constitute structural error under either Herrera or other New Mexico law. Rather, this court views the defendant's arguments on the deferral of jurors' questions as implicating a review of the competency, quality, or sufficiency of the evidence presented to the grand jury. But remember, evidence questions will only be taken up if bad faith was demonstrated. Continuing with Judge Sommers, to undertake such a review, the court would necessarily have to evaluate the quality or competency of the evidence presented, speculate as to how a witness may have answered a deferred question, and assess whether the witness's testimony in response to the question may have been exculpatory. However, in the absence of prosecutorial bad faith, this court may not engage in this type of review. D, the court does not find error with respect to the contested jury instruction. Defendant argues that the state provided an inaccurate jury instruction regarding a critical element of the charged offense. So let me provide some context here. So the jury instruction used by the state is the uniform jury instruction on involuntary manslaughter for New Mexico. We've gone over it a number of times. It's kind of a fill-in-the-blank form. So it says this defendant, and you would fill in the defendant's name, engaged in this conduct, and you would fill in the conduct. In this case, pointing a real gun at Halyna Hutchins and cocking the hammer and pressing the trigger without ensuring there's no ammo in the gun. And that constitutes, if you, the jury, the trial jury, concludes that constitutes essentially recklessness necessary for involuntary manslaughter, then you, beyond a reasonable doubt, then you would return a verdict of guilty. What the defense wanted was a jury instruction that said, in effect, that Alec Baldwin had to actually know there was a bullet in the gun. That it's not enough that there might have been a bullet in the gun, that he failed to check. And obviously, this would be a decisive issue, right? Because no one is claiming that Alec Baldwin knew there was a bullet, a live round in the gun. What the state is arguing is that the totality of his conduct, the multiple breaches of fundamental gun safety rules, the pointing of the muzzle of what he knew to be a real gun at Halyna Hutchins, the cocking of the hammer, the pressing of the trigger, without having ensured that there was no live ammo in the gun, which obviously he didn't because there was live ammo in the gun, that collectively that constitutes either negligent handling of a firearm or a failure to use due caution and circumspection in the handling of a firearm, which qualifies as involuntary manslaughter. The defense wanted the jury to be told, well, he had to know there was a live round in the gun, affirmatively no, and the state would have to prove that he knew beyond any reasonable doubt. The state objected because that's not actually in the New Mexico jury instruction, but it's what the defense wanted. So when the defense didn't get the variation of the jury instruction they wanted, they portrayed that as the prosecution having given the grand jury an incorrect jury instruction. So that's the context. Defendant argues that the state provided an inaccurate jury instruction regarding a critical element of the charged offense. Specifically, defendant takes issue with the prosecution's version of element 1 of Uniform Jury Instruction 14-231, involuntary manslaughter, essential elements, which read, quote, the target discharged a firearm during the production of a movie without first verifying the firearm contained no live ammunition, and while the firearm was pointed in the direction of another, close quote. When a uniform jury instruction exists, that instruction must be used without substantive modification. So a little context here too, folks. So in the old days, 100 years ago, every time there was a criminal trial, at the end of the trial, the state and the defense would draft up jury instructions. They would write them and they would present them to the judge. And of course, the state proposed jury instructions would be favorable to the state and the defense would be favorable to the defense. And then the judge would have to read all these drafted jury instructions and come up with some amalgamation of jury instructions that the judge, felt accurately reflected the law. Well, as you might imagine, this was a lot of work and kind of chaotic, and you ended up with different jury instructions in very similar cases and different verdict in very similar cases because the jury instructions were different. So pretty much every state has converted to standardized jury instructions, or as New Mexico calls them, uniform jury instructions. And these are, it varies from state to state, but these are typically jury instructions that are drafted by expert committees. Often the state Supreme Court will pull together committees of prosecutors, defense lawyers, judges, law professors, who will review the law, the case law, review the statutory language, all kinds of stuff. And they'll draft up jury instructions, and then the state Supreme Court will give them a stamp of approval. And those are the jury instructions that the trial courts are supposed to use. The quickest way for a trial court to get reversed on appeal is to use non-standard jury instructions. Now, as I said, jury instructions are often kind of fill in the blank. In fact, you can see that, fill in the blank here. Name of target, Alec Baldwin, did this stuff. Describe the Targets Act. Or it doesn't say it says one. Sorry. One, Alec Baldwin, whatever the underlying conduct was, that the state is alleging was reckless or negligent. So there's always that fill in the blank nature, but that filling in the blanks is not modifying the jury instruction. The modification that cannot be made without a very high risk of reversal is a substantive modification, changing the legal burden, changing legal thresholds, changing legal definitions, for example, which is what the defense wanted here. They wanted to add language to the uniform jury instruction that does not exist in the uniform jury instruction. Recklessness does not require a knowing misconduct in the sense of the danger is going to occur. Recklessness, the classic example, is drunk driving, right? You get drunk at a bar, you get behind the wheel, you're driving home, you're not intending to run anyone over. But when you get behind the wheel drunk that you're creating an unjustified risk of death to another. And if you do run someone over, that's involuntary manslaughter, reckless manslaughter. You didn't intend to hit them, but you knew you were creating the risk, you disregarded the risk, and someone died as a result. So it doesn't require, for example, that when you got behind the wheel and started your car drunk, that you knew there would be pedestrians at risk. You knew there were pedestrians in the walkway on the way home. That's not what's required. And the same way, it's not required that Alec Baldwin knew there was live ammo in the gun. He just had to be aware that the risk existed. Let's see. When uniform jury instructions exist, that instruction must be used without substantive modification. Substantive modification. Fill in the blanks is appropriate. For fundamental error to exist, the instruction given must differ materially from the uniform jury instruction. It must omit essential elements or be so confusing and incomprehensible that a court cannot be certain that the jury found the essential elements under the facts of the case. In pertinent part, in this Baldwin case, and modified for furnishing to a grand jury, Uniform Jury Instruction 14231, the involuntary manslaughter jury instruction reads, quote, for you, the jury, to return an indictment against the accused for the crime of involuntary manslaughter, you must find that there is probable cause to believe each of the following elements of the crime. 1, name of target, Alec Baldwin, and describe target's act. So here is where the state would fill in that he pointed the muzzle at Halyna Hutchins, operated the gun, pressed the trigger without ensuring there was no live ammo in the gun. Judge Sommer continues, here the court does not find error in the state's construction of element 1 of the involuntary manslaughter instruction, as the state filled in the blanks. The language of the jury instruction merely describes the alleged act and attendant factual circumstances on which the prosecution sought a finding of probable cause. In other words, in accordance with the statutory charge of involuntary manslaughter, the instruction alleges the commission of a lawful act which might produce death without due caution and circumspection. The given jury instruction does not materially differ from the uniform jury instruction, omit essential elements, or constitute a confusing or incomprehensible charge. E. This court concludes that the prosecution adequately advised the grand jury with respect to the target evidence alert letter. Judge Sommer writes, defendant contends that the prosecutor erred by not explaining the significance of the then target's, Baldwin's, evidence alert letter when read by the prosecutor to the grand jury. Specifically, defendant states, Morrissey, the prosecutor, never explained the meaning or practical significance of Baldwin's alert letter, why it was being read into the record, or what the grand jurors were supposed to do with it. Nor did she explain that the witnesses identified in the alert letter were available to testify. This court, Judge Sommer writes, finds no error. Pursuant to statute, the target or his counsel may alert the grand jury to the existence of evidence that would disprove or reduce an accusation, or that would make an indictment unjustified, by notifying the prosecuting attorney who is assisting the grand jury in writing regarding the existence of that evidence. That's the alert letter. Further, New Mexico statute sets forth the procedure for a target to alert the grand jury to the existence of exculpatory evidence, with the prosecutor acting as the conduit for this information. Notably, Form 9219 also sets forth a form grand jury evidence alert letter for use by a target. The form includes a preamble language generally advising that in accordance with the rights and obligations of the grand jury under New Mexico law, the above noted target of the grand jury proceeding in this case requests the grand jury consider the following evidence. Here, the state read Baldwin's evidence alert letter verbatim to the grand jury. After receiving this letter, the grand jury opted not to consider additional evidence offered by Baldwin. Other than alerting the grand jury to the evidence, New Mexico law does not expressly require the prosecutor to provide additional instruction to the grand jury. In addition, every grand jury impaneled for a term of service receives instructions by the grand jury judge substantially similar. Explanation of proceedings. The grand jury docket reflects that a similar instruction was given to the grand jury impaneled to consider the grand jury presentation at issue here. The instructions to the grand jury provide in relevant part, the grand jury has the power to order the attendance of witnesses and to cause the production of public and private records or other evidence relative and relevant to its investigations. It has the authority of this court to subpoena witnesses. If you have reason to believe that evidence not presented to you is available that may excuse or disprove a charge or accusation, or that would make an indictment unjustified, then you, the grand jury, may order that evidence to be produced. This is all told to the grand jury and was told to the Baldwin grand jury. Evidently, Judge Sommers continues, after the state read the target's evidence alert letter, the grand jury decided not to order production and presentation of the target's evidence. This court is not in a position to second-guess the grand jury's decision in this regard and will not disparage the grand jury by doubting its ability to remember the grand jury judge's instructions. This court finds no error in the actions taken by the prosecutor with respect to the reading of the evidence alert letter to the grand jury. F. The court does not find that the prosecution violated the instructions of the grand jury judge. Defendant's reply, this is the last of the complaints of the defense here on the grand jury indictment. The last of the defense arguments on why the indictment should be overturned or should be dismissed. Defendant's reply expounds upon defendant's argument concerning the state's compliance with Judge Ellington's order on the state's expedited motion. Defendant explains, the state violated the court's order, Judge Ellington's order. The state did not make the witnesses readily available. The state also violated New Mexico law because it failed to present any of the exculpatory evidence from those witnesses or the documents Baldwin identified in his alert letter. Judge Sommers replies to this defense argument. Defendant's arguments are not well taken. That's a polite way for the judge to say defendant's arguments are crap. First, as to whether the witnesses were made readily available by the prosecutor, Judge Ellington's order, the court declines, let's see, so many internal quotations. So Judge Ellington had ordered the court instructs the state to make readily available the proposed tangible evidence and potential witnesses to avoid scheduling disruptions if the grand jury wishes to hear the evidence once alerted. However, the court declines to provide additional instruction to the state on securing witness availability. So here, what the judge at the time, Judge Ellington, was saying to the prosecution was, hey, if the grand jury says they want to hear evidence or witnesses, you have to make them readily available. The prosecution has to make them readily available if the grand jury wants to hear the defense proposed evidence or witnesses. Judge Sommers here continues, given the language of the order, this court concludes that the prosecution did not violate Judge Ellington's instruction. Judge Ellington clearly declined to instruct the state on the logistics of securing the availability of targets, alerted witnesses, and tangible evidence. Further, defendant takes the order's reference to make readily available out of context. In material part, the order reads, the court instructs the state to make readily available potential witnesses to avoid scheduling disruptions if the grand jury wishes to hear the evidence once alerted. Thus, Judge Ellington's instruction is ambiguous in that the instruction could be interpreted to mean that the state was to make witnesses A, readily available, that's one interpretation, or B, readily available if the grand jury sought their testimony, which they never did. Therefore, given Judge Ellington's declination to provide logistical guidance to the state and the ambiguity of the instruction, this court does not find that the state violated Judge Ellington's order. Second, this court rejects defendant's argument that the state violated the court's order and New Mexico law requiring that the exculpatory evidence be presented. Nowhere in the January 11th order by Judge Ellington did the judge order the state to present exculpatory evidence to the grand jury. Further, as developed in greater detail above, New Mexico law does not require a prosecutor to present exculpatory evidence to a grand jury or require a grand jury to even consider exculpatory evidence after alerted to its existence. Therefore, this court concludes that the state did not violate Judge Ellington's January 11th order. G, the court rules on the merits of the defendant's motion to dismiss. Defendant asserts, quote, the state responded with a 32-page jeremiad against Baldwin and his lawyers that does not cite a single legal decision, does not distinguish Baldwin's authorities, and spends no more than 5 pages addressing the core legal issues raised in Baldwin's motion. Further, defendant concludes that the state's failure to distinguish Baldwin's authorities or offer legal authority of its own constitutes a waiver, so that the state defaulted on these legal arguments by the defense. Judge Sommer writes, this court declines to grant defendant's motion to dismiss on grounds of waiver. New Mexico case law recognizes a strong bent in favor of deciding matters on their merits, not technicalities. Accordingly, the court addresses defendant's motion to dismiss on its merits, not technicalities. Conclusion, it's therefore ordered that defendant Alec Baldwin motion to dismiss the indictment is hereby denied. Denied. Judge Mary Marlow Sommer, District Court Judge. Did they put the date here? They kind of bury it. It is in the paperwork here. Let's see. It's at the beginning of the order. May 24th, 2024. So a week ago last Friday. And there we have it, folks. Alec Baldwin is going to trial. Unless something bizarre happens. But he's not getting his indictment dismissed. Not by this judge, for sure. All right, folks. So we are now at the point where it's time for Q&A. We really only do Q&A from our Law of Self-Defense members. The good news is that membership is dirt cheap. It's only 99 cents to be a Law of Self-Defense member. 99 cents gets you a 2-week trial. After the 2-week trial, it's still dirt cheap to be a Law of Self-Defense member. It's only about 30 cents a day, less than $10 a month to be a Law of Self-Defense member. And then you get all your questions and comments addressed for free on all these live streams. But you do have to be a Law of Self-Defense member because I only address the ones that are in the member chat. So as a member, you access the member-only live stream and the member-only chat. Put your questions and comments in there. Which means, since we're not taking questions from YouTube or Twitter or Rumble, it's time to say goodbye to you folks on those channels. If you're a Law of Self-Defense member, don't go anywhere. I'm about to read through your comments and questions and answer them. If you're watching this on YouTube, Rumble, or Twitter, the show's over for you. So have a great remainder of your weekend. And I look forward to seeing you all again real soon. Again, Law of Self-Defense members, don't go anywhere. I'll be right back.